Hello, dear viewers. I, Enaniya, Assistant Professor in Government Law College, Ajmer, is before you to discuss the topic of parliamentary privileges. Yes, this is a very important topic which we do study and we need to study in the subject of the constitutional law of India. The word parliamentary privileges itself makes the fact very clear that these are the very special sort of rights which are given, which are vested in our members of parliament as well as the members of state legislatures and various other people whom we will discuss today in our lectures. But the basic concept is need to be understood, that is, what is the requirement of these privileges. If and only if we understand this concept, we will always remember these parliamentary privileges, because the reason behind, the logic behind the inclusion of these provision must be understood beforehand, and then after that we can use it for the various practical purposes. So let us start with the saying of Sir S. Erskine May, who is a very important jurist in this regard, because he has observed very important facts in United Kingdom as well, and we have based our constitution's provisions of parliamentary privileges on England's constitution, in which Sir Erskine May's role was really important. So he had stated that parliamentary privilege is the sum of the peculiar rights enjoyed by each house collectively. Okay, clear? So it is the sum of the rights enjoyed by the house collectively as a constituent part of the High Court of Parliament and by members of each house individually. So I think it is very clear to you all that it is containing both the collective rights as well as the individual rights. The collective rights are contained in the houses themselves, whereas the individual rights are vested in the individual parliamentary members. Clear? Without which they could not discharge their functions. Okay, so these are the very important rights without which we cannot even imagine how they would discharge their functions, because their role is very crucial, and until unless these rights are vested in them, they cannot be expected to work as efficiently as they can with the vesting of these powers. Clear? Thus, privilege, though a part of the law of the land, is to a certain extent an exemption from the general law. So, it is a sort of exception to the general law, because these are the privileges which are of highest importance, and they are provided to the members of the parliament as well as the houses of the parliament. Certain rights and immunities, such as freedom from arrest, freedom of speech, belong primarily to individual members of each house. So it is available to even our members of parliament. You must always remember that though our constitution's provisions with regard to parliamentary privileges is based on England's provisions, but we must understand that the England's parliament is sovereign and it is above every other body, whereas in India our parliament is a creature of the constitution itself, so uh, it will derive the powers from the constitution itself, and the limitations, if any, will be imposed by the constitution. Whereas in England, it is not so. The parliament is all powerful, it can frame any law, it can vest itself with any power, it can work in any manner it wishes to. Clear? Whereas our parliamentary privileges provisions have to function within the four corners of the constitution itself. Next, the individual rights are mainly the freedom from arrest and freedom of speech. Clear? The freedom of arrest right which exists in Indian context is freedom from arrest in civil matters only. Clear? Next, and exist because the house cannot perform its function without unimpeded use of the services of its members. So here he has Sir Ericsson May has cleared this fact that the houses of the parliament cannot function, and we cannot even imagine a situation in which such house can function without the vesting of such powers. Okay, freedom of speech and freedom from arrest, these are the two individual rights which are given to the members. Okay, now we must also understand that these are the rights given to them individually. Next, other such rights and immunities, such as power to punish for contempt and power to regulate its own constitution, belong primarily to each house as a collective body. Okay, now the house not only has the collective rights as well as they have the individual rights vested in the respective members of parliament. Okay, the collective rights are being the power to regulate its own constitution. Okay, it can regulate its own process. It is very much competent because it is the supreme law making body. So therefore, what to talk about the power to regulate its own business. Okay, so it can even punish for its contempt. Okay, since it's a very important body, very important creature of the constitution, which does a very vital role in the functioning of the democracy in our country. Therefore, it must always be looked upon as a very dignified and on a body having the highest honor. Okay, so therefore its respect must and dignity must be preserved at every cost. Therefore, the power to punish for its contempt is also vested in it. Okay, now for the protection of its members and the vindication of its own authority and dignity. So the concept is very clear. If we read the next lines, that is to protect its own authority and dignity. Until unless it will protect its own authority and dignity, no one will respect and no one will look at with honor, and it cannot command the respect of the general masses. Fundamentally, however, it is only as a means to effective discharge of collective functions of the house that the individual privileges are enjoyed by the members. Okay, so it has this statement has made it very clear why such individual privileges are enjoyed by the members, why such collective functions are attached or vested in the houses. The reason being is so as to effectively discharge its functions. So, Sir Erickson May and his statements are very important, and his treatise on parliamentary privileges is looked upon with utmost respect, not only in England but across the globe in various democracies. Next, we must understand what is the word contempt. We had heard the word contempt here. Okay, so when we were talking about power to punish for its contempt, now we are trying to understand what is the meaning of this word contempt. Contempt is, if we speak generally, contempt is an act or omission which obstructs or impedes either House of Parliament in the performance of its functions. Okay, so it might be any act, a positive act or a negative act, that is omission. If something is done, that is an act, and something is desisted from being done, that is omission. Okay, so such an act or omission which obstructs or impedes the houses of the parliament in the performance of its functions. Okay, so whatever stops the houses from performing its functions, or whatever obstructs or impedes any member or officer of such house in the discharge of his duty. So either the house is disturbed, or the individual member or any officer of such house is disturbed in the discharge of his duty, or something, or such an act and or omission which has tendency directly or indirectly to produce such results as may be treated, which may be treated as contempt even though there is no precedent of the offense. So I think now the fact is very clear that whatever hampers the working of the houses of the parliament or the individual members or the officers of the house in the discharge of their functions is a contempt. Okay, even though there is no necessity that such an act is set as a precedent earlier. Okay, so it might not be treated as an offense earlier, but it might be dealt with as an offense in the succeeding scenarios. Clear? So now let us move on to the next part of our today's lecture. Now the most important thing which is provided in our constitution, now we will understand the constitutional provisions on the parliamentary privileges. There are mainly two articles which deal with the parliamentary privileges. First one being is Article 105. The Article 105, the heading of Article 105 reads powers, privileges, etc. of the houses of the parliament and of the members and committees thereof. So, by a plain reading of the marginal heading of Article 105, it is very clear that these powers and privileges are collectively provided to the houses of parliament as well as to its members and the committees, the various committees of the parliament, which are known as parliamentary committees. Okay, so 105 deals with the powers and privileges of the parliament, whereas Article 194 deals with the powers and privileges of the houses of legislatures of the state. Okay, the marginal heading reads powers, privileges, etc. of the houses of legislatures and of the members and committees thereof. So, Article 194 in itself contains the powers and privileges of the state legislatures collectively and of the members and committees. Okay, so the members might have these parliamentary privileges individually, whereas the committees may have the collective parliamentary privileges at state level, state legislatures level. So if there are two houses of legislature in the state, then both are included, and if not, then the individual state legislature. Now, let us read and understand what is contained in Article 105. Article 105, the marginal heading is Power, Privileges, etc. of the Houses of the Parliament and of the members and committees thereof. Okay? Now, the first clause of Article 105 provides that there shall be a freedom of speech in the Parliament. Now, you might be surprised because you have already read Article 19, Clause 1, Subclause A, in which the freedom of speech and expression is already provided. You might wonder that what was the necessity to provide it again when we are reading the Parliament in our constitution. It is not a repetition of the same right. It is a very distinguished right as compared to Article 19, Clause 1, Clause A. Okay, that is available to the citizens of this country. Okay, whereas this freedom of speech in Parliament is a very paramount kind of right. So, the members of the Parliament and the members of the committees, various committees of the Parliament, have the freedom of speech in Parliament. The reason being is the if the members do not have the freedom of speech in the Parliament, they cannot speak whatever they want, whatever is required in the Parliament, because the ideals of the democracy requires the important discussions to take place in the Parliament, and we do know that whatever happens in the country, the important things, whatever occurs in the country, are discussed in the Parliament. Okay, so for example, if let's say the new laws are created and the working of these laws are challenged by the people of the country, then such discussions can again be introduced in the Parliament, and the various members or the individual member, any individual member might raise an issue pertaining to the same, or if any law is not proper so as to cover the subject exhaustively, or if there are major lacunas in our legal system, uh, if it is contained in any particular law, then such thing can be discussed by individual member of the Parliament, and until and unless he is possessed with the freedom of speech in the Parliament, he cannot speak such things. The right contained in Article 19, Clause 1, Clause A is of restricted nature, and it is restricted by Article 19, Clause 2. Whereas the freedom of speech in the Parliament is totally different, because there is no restriction imposed upon it. So the member of the Parliament may speak whatever he wishes, okay, and no particular action will be taken in this regard. Though the speaker has all the powers to punish for its contempt, we must know the only limitation is this. So, we know that there is a freedom of speech in the Parliament, okay, and we must also know that none of the members of the Parliament are answerable in any court with respect to whatever is said by him in the Parliament, or with respect to how he has voted in the parliament or in any committee or whatever publication is made by the authority of the parliament. Okay, so no action will be taken in court, and no such person will be answerable in the court of law. Okay, provided that publication has been made by the authority of the either houses of the parliament. So I think it is very clear to you people. Now, I think we will continue our lecture in the coming videos. Okay, so it is to be continued. So, thank you for listening so carefully and have a great day ahead.